As you all know, it is, remitter came back from the Court of Appeals. Your motion for reconsideration was denied, Mr. Jimenez. I signed the remitter, and it is my intention to follow the instructions of the Court of Appeals. I understand, which requires me to call a mistrial. One of the first things I want to address is, when I called the jury in for today, one of them, who's an alternate, immediately contacted my office and said, hey, I made travel plans in March to be in Massachusetts from today through, I think, the rest of the week. I informed that juror that they could appear via Zoom. Given my intention to follow the remitter, I'm going to have these people here for 15 minutes. I'm going to bring them out, let them know a mistrial has been called this case. We're not going to go into the whole whys and wherefores. They can watch it on the news. And then I'm going to dismiss them. And then I will entertain your motions, obviously, Mr. Jimenez. But does anyone have an objection to that you're appearing via Zoom? Right now, she is in a breakout room, so she is not even watching this proceeding. She is sequestered as the rest of the jury is. But given my intention is to comply with the remitter today, I didn't feel the need to drag her down here for Massachusetts. Any objection from the city?
No objection to the state, Your Honor.
Mr. Jimenez?
You know, two very quick things. Very first, obviously, no objection to the Zoom, that the jurors may be a Zoom. But before we get into anything, the first time I get a chance to talk this morning, good morning, I did want to place an objection on the record as to the security protocols. I understand that people, the public, are being asked to show ID and to put their phones away as a secondary inspection. I am very aware that we're in a courthouse. My courthouse is a secure facility, and the sheriff is in charge of this, and they make their own rulings. But I do want to make it clear on the record of my objection. We understand that every single person that walks into this courthouse gets screened by whatever protocols have been established by the sheriff's department for as many years as he's been elected. When it comes down to a secondary screening for this trial, that is the problem that I have. This is a similar problem that I've had in previous trials in this courthouse with this sheriff when I was part of the YSL trial. In that case, there was some arguments that were never actually flushed out, but there was the state claimed that it was for security reasons. And that was a case where we're dealing with, in the courtroom, at least 8 co-defendants, their attorneys, people were charged with murder, people were charged with very violent crimes. It was alleged that they were the most dangerous gang in Atlanta, in Georgia. Ultimately, most of those cases either got dismissed, acquitted, or got probated sentences, and there was never any threat of violence that happened in the courtroom, but that was their basis. In this case,
Some people would say those secondary security measures work then.
and I guess they got,
Here's my thing, Mr. Jimenez. These folks with all these cameras have followed Rule 22s. Here's the thing about phones these days. They are also recording places that are not obvious. So if the sheriff's your objection is noted for the record. Anything else?
yeah, I just wanted to finish my thought real quick. The phone, I agree with you, phones can be, somebody came out, there was one, the only one find out until somebody touched up there, hey, it was nice seeing you today.
Also, I'm Instagram famous.
I'm not, but hopefully they'll follow me eventually. The issue, the biggest issue that I want to make it clear is that people are being asked to show ID to come into this courtroom. And first of all, you need ID to get ID. Some people don't have ID. So are those people not welcome in the open courtroom? And also, it is a chilling effect. We're dealing with a case about First Amendment. We're dealing with what our defense is. There's a chilling prosecution of freedom of speech and a right to protest.
If you want to file a motion and have the sheriff come in here, do you think your objection's noted for the record?
Right.
Keep on track.
I'll work on my motion, Your Honor. I'll get it
What
filed
you need to do.
as soon as possible. And so it doesn't be portrayed as a last-minute motion. I did not know the secondary inspection until this morning when I came in and I noticed that this is something that I was not aware of. This is why my motion will be coming shortly after me being aware of a secondary inspection for the public to be present.
All right, so, okay, so as I said, I did also get, we have some motions that were filed. An anticipatory objection is what I'm gonna call, that's why I didn't respond to your objection, because, not timely, because I haven't granted the mistrial yet, nor to your response from the state. It's not right yet. It will be in about 15 to 20 minutes, all right? I also anticipated the motion you filed this morning, which also isn't quite right yet until I declare the mistrial. I'm also going to go out on a limb and say that you're going to want to directly appeal should I deny that being barred. You're going to want to appeal.
That is correct.
Okay. Also, we're going to address a midnight filing of witness list that still isn't, well, let's see what that shows. Because I was filed on July the 2nd. Hey, they're showing up.
You guys, that's just my witnesses. That's just my two witnesses.
That's your witness list.
Yes,
Okay,
sir.
I got you. All right. Filing a speedy trial demand is an announcement of ready for trial. It's an announcement for ready. So, and also in your motion that was filed at, let's see, straight up midnight tonight, you're asking for one of your alternatives to excluding is asking for 30 days notice. That's, I'm looking, given the volume of discovery and length of witnesses, the requested 30 days of notice. It should order the state to produce no later than 30 days for the commitment. So the presentation of evidence or a minimum of later than 30 days. That sounds an awful lot like it continues to me.
Ma'am?
Yes, please.
Absolutely not. We're not asking for convenience. That is not what I'm asking. What I am asking for is for the, as you know, the jurors on the other side of that wall.
Mm-hmm.
We are on trial as we speak. Court of Appeals determined that trial had started and we are on trial.
Mm-hmm.
What I am asking for is that the additional names that were given, which I believe is 104 names, and I guess 140 some names, 104 of those that were given to me 9 days and 13 hours ago are brand new names in the middle of the trial. These are not names, but maybe the state can give us an guidance on that. These are new names that they didn't know about when we picked the jury and started this trial back in December 2023. These are in addition, as you can see from my motion. What I'm asking for is for all of those new people to be excluded because they're on time and they were only given to me in the middle of trial, 9 days and some hours before we reconvene. In the alternative, if the court is not willing to exclude these new people, then I am asking for time. But I wanted to make it clear that we got a bunch of brand new names. I have to make the record, and that's what we're asking for. And the reason is because we are on trial as we speak.
Okay. Mr. Fowler or Ms. Haley, I don't know who's going to handle that one.
Hi, Your and good morning. We sent the supplemental witness list on June 27th, 2 Fridays ago. We do the math, that's 10 days ago. Is it 9 days, 9 hours, and some odd seconds ago? Yes, it is, but for the purposes of calculation, it's 10 days ago. And I understand he's saying it's in the middle of trial. I think he's referring to what we're currently, as we're sitting here at posture at 9:40 in the morning. I understand that, but I also understand that the court is going to follow the directions of the remitter that came from the Court of Appeals. So there's going to be another trial.
I think I indicated that to both parties at our first hearing back in May, that I was going to follow the directions of whatever the Court of Appeals told me to do.
You did right. And so, if we're talking about witnesses for the current trial we're sitting in right this very second, which, as I understand it, there's about to be a mistrial declared, so there's not going to be any further evidence. That was submitted for the purposes of the trial that is coming up. That is the one that is coming from the remitter, if that makes sense.
Fair point. I think what you're trying to say is, all right, if I bring him out, when I bring him out, declare mistrial, and Mr. Jimenez files his objection, and if it comes to the fact that, you're going to appeal, that witness list is still on the record. And while the appellate process is trying to speed up, you're certainly going to have more than 30 days between an appeal and an opinion, between the notice of an appeal and opinion. So you're going to get your time by hook or by crook there. Okay?
When it's appropriate, Your Honor, and I know those jurors are waiting on us, I'm sure they have things to do on busy Monday morning. I just want to address the appellate issue, but I don't think now's the time. So whenever I may do that.
No, it's really my intention to bring them out, let them know what's going on, cut them loose, and then we can continue our discussions. Okay. So, hold on one moment. Ms. Bentley, do you have the alternate juror in the breakout room now?
Yes, sir. They're in the breakout room.
Okay. So do we have two of them?
No, sir. There is one.
One. Okay, fantastic. So at this point, if we could get the jury, please, and you can allow the alternate into the Zoom. I mean, yeah, you can take her out of the break.
One quick thing, I just wanted to let the court know that my client, Ayla King, goes by they, them, and we prefer if they be addressed that way.
Defendant is gender neutral and all inclusive. Or accused also gender neutral and all inclusive.
Or
Fair enough. Oh, no. One moment, y'all.
Everybody know. Swipe the box.
Further developments.
You know not to swipe the box, right?
Yes, ma'am.
Okay.
All right. Further developments, my glasses in the office. Okay, so everything up here is fuzzy. It has been brought to my attention that whilst we were talking, 3 of the jurors did not go back there. 3 of them were out there. And we have a grand total of, oh, that's nice. We have 10 jurors physically in the building and 1 alternate not. So we do not have the 12 jurors. I believe we have 9 jurors, 1 alternate, and 1 alternate on Zoom. So, 2 ways to handle that, given what I've talked to y'all about, is we can go get them here. It'll probably take till tomorrow morning. And then I'm gonna do what I've told y'all. Or, I'm willing to proceed, but that's entirely up to you all. It's your objection to make or not make. I don't have a dog in that fight. So, I'll just start with the state. Do you have any objection to proceeding as is?
No, I do not.
Mr. Jimenez?
I would never ask the court to arrest anybody, so no.
Well, I wouldn't arrest them. We would just give a
Give
little
them a ride.
verbal encouragement and maybe a free ride. No, I'm not looking to throw anybody in here. But do you have any objection to proceeding, given the direction that the court is going to go with this?
The only objection I have is an objection to the mistrial. Whether you've already made up your mind after reading my motion.
I haven't made up my mind.
Okay, well then,
The Court of Appeals made my mind up.
and that's what the, I did file a motion shortly after you signed the remitter. I don't know if you wanted to address that one before signing anything, but that is,
I will address 16-1A.
thank you.
So, with that being said, I also have one more thing. One of the jurors, the request has not been answered. wants to talk to the judge before he or she comes out. My answer to that would be no, obviously. But for whatever reason, that juror is got some cold feet. I don't know how y'all want to address that situation. I'm perfectly willing to take some suggestions from y'all, because otherwise I'll just bring them out. But I don't want to bring out someone who's, for whatever reason, logically, illogically, rationally, irrationally, I don't know what the reason is, he or she wants to talk to me. But I'm certainly not going to talk to her without letting you guys know ahead of time, and giving permission or not. If I were to talk to her, it would just be to let her know what's not happening. You're going to go home. And also, again, and the camera guys know this, you don't show the faces of the jurors. Right? Easy. You get me, you get the witnesses, you get the lawyers, but you don't get the jurors. So I can let her know that too, that he or she will not be on the box tonight. Any suggestions?
No, Your Honor, given the direction of where we're going with this, I have no objection to the court speaking with the juror prior to bringing them in for whatever purpose. There's no harm in that, given the direction that we're going.
Mr. Hernandez?
Your Honor, I was going to mention the exact same thing you did. There is no exposure of their likeness because the cameras are not allowed to show them. We would like that whatever concerns this juror has to be voiced to in open court, so we know what the concern is. It might be that, it might be something else that we are interested in. We have no objection to the court saying through a message, maybe through a note, you're not gonna, if you're worried about being on camera, you're not gonna be on camera, and that's the extent of it. But if there's an actual substantive question from this juror, we would like to hear it ourselves as well.
Deputy, go, if she would write her concern down on a note, and I can make that courts 1 or courts whatever. And just, if she's got a piece of paper, she wants to write her concern out and bring it out in the form of a note to me, please.
Yes.
Thank you.
And I only know that because she said that to me over the speaker.
Okay. When she buzzed in, it's a hardship. It's not going to be a hardship for much longer. I wouldn't suspect. We're going to unhard that ship.
You got a haircut?
All of them. Every summer I get shorn like a sheep. Shaving and haircut, 2 bits. It's hot outside, you know? I mean, come on, it's hot.
Georgia.
It's right. That's why you get a haircut in the summertime, and it grows long in the wintertime. The wife prefers it long. You can share that with all of you guys. When we met, it was down to here, so. And then I realized it got hot in Georgia.
Yeah, I got rid of my hair too. I miss it. It feels weird.
It grows back.
You know what
Unless you're my brother. Wow. She's just saying it's a hardship, it's a larger make it courts one, you know, I really wanna read all that?
Say it does not drop.
It's okay, because if it's gonna be on the record, I'll read it later.
Yeah. Life's busy, I don't have time. That's what it says. That's fine, bring them on out, please. I don't know that I can grant a retroactive hardship anyway. Court's one.
First piece of evidence.
And then this trial, that's. All right, for the jurors. Anywhere, any seat, make it stuff come. Great, thank you. Well, most. Welcome, y'all. I do have got the note from one of you. I'm not gonna ask that to identify themselves. But I'm gonna take care of the hardship. Thank you for your service. I know this has been a long and winding road. Okay. And it's been some 16 months since y'all last saw this courthouse. And at this time, I am going to declare a mistrial in this case, which means y'all are done. So whoever had the hardship, you no longer have the hardship. And that goes, I know we have a nice lady up there in Boston. Boston, right, man? Your jury service is done in this case.
Thank you.
This trial has been declared. I want to thank you for your service. I don't know that my office has been in touch with you, but I know Judge Adams was in and out with y'all. Y'all were curious, trying to figure out when the other shoe was going to drop and when we were going to hit the ground running. But we're going to see if we can't get 15 of your fellow citizens to come in and see what happens next. But thank you very much. Y'all don't.
No, you're right.
Mr. Hernandez.
No, they probably want to go home to their
Yeah.
families.
Okay. Thank you all very much.
Thank you.
All right, juror. That's what you've had before house yet, right? Credit card, no good.
Wow, thank you.
Okay. And there she goes. Alternate juror, just took off this one. Okay.
No surprise, Your Honor, I have to object to the defendant mistrial and we move for acquittal.
Let me finish filling out court's one. Would you please, Mr.
Just saying, I don't want to say that I waived because I took too long.
I will ask. Okay. The court has declared a mistrial in this motion. At this time, it is the court's intention to bring in another jury panel and begin selection meeting. Before I do so, does either side have any motions?
At some point, I believe the defendant does.
Yes. Go ahead, Mr. Hernandez.
Your Honor, at this point, we move for an acquittal.
Oh, and your objection to mistrial is noted for the record.
Your Honor, we do believe that the mistrial that has been declared for our objection is not one of the types of mistrials that fall under 1618 that would allow the state of Georgia, the government, to go forward with the trial against my client, Ms. King. So based on that, we are ready to file a plea in bar, asking for the court to dismiss all charges against Ms. King and bar any further prosecution for this particular event or any other things that are related to the same actual transaction relating to their alleged activity on March 5th or anything to do with this alleged organization, Your Honor. Like I said, as soon as I get a chance, I will e-file it, but I have provided the court with a courtesy copy of what I intend to e-file shortly. And I think our brief is pretty thorough, but we can also put some arguments on the record.
Here's what I'll do. Now that the mistrial is timely, the objection to the mistrial is timely, I'm gonna deny your motion. I'm gonna deny your objection to the mistrial. And then I'm going to deny your objection, deny your plea in bar. And I'll get those orders out so that the clock starts running and you can get that stuff out. And I'll get those orders out today. But I would note 1618 is the statute regarding when prosecution is barred by former prosecutions. That's what your motion was traveling under?
That's correct.
Okay. And it says the prosecution is barred. The accused was formerly prosecuted for the same crime if it resulted in either convictions or acquittal, or two, was terminated improperly after the jury was impounded and sworn. That's your objection. And you're alleging that it was terminated improperly. And Section E deals with termination under any of the following circumstances is not improper. And that's not an exhaustive list of impropers or not propers, not improper. Obviously, the accused is not consenting. You understand that. But E2, the trial court finds that termination is necessary because it is physically impossible to proceed with trial. That's the case. Prejudicial conduct in or out of the courtroom makes it impossible to proceed with the trial without injustice to the defendant. The jury is unable to agree upon a verdict or false statements of a juror. We don't have C or D there. And I think that B is more the issue here, in that the Court of Appeals found that the barring of the public and the media from jury selection was prejudicial. So I don't know. I'm going to deny your pleading bar as well. Anything else?
If I may, Your Honor, just to add on one thing on top of that, Article 1, Section 1, Paragraph 18 of the Georgia Constitution provides that no person shall be put in jeopardy of life or liberty more than once for the same offense, except when a new trial has been granted after conviction or in the case of a mistrial. And so the constitutional provision that precludes double jeopardy carves out an exception in the event of a mistrial. Of course, here this court just declared a mistrial, and so for the purposes of the constitutional argument, the defendant's motion should be denied as well.
Article 1, Section 1, 8.
Paragraph 18, Your Honor. And I have copies if the court would rather than walk with a copy.
No. Well, and you understand Mr. Jimenez's point is, yes, he's not arguing that mistrial was made, he's just saying it was improperly.
I understand, Your Honor. Yes.
I got you. Okay. Court's ruling is still gonna stand. I've got your motions. I'll get them filed today, get you courtesy copies, so well, you should get notification as soon as I file them. And that'll start your clock running. You see the point in bringing a jury down here and starting that whole process if you're just gonna run back across the street. And then we'll get started on some of the other 60 days. Anything further for today?
Your Honor, if I may, given that the defendant still has a valid statutory speedy trial demand running pursuant to 17-7-170, I would note that under subsection E, it does say if the case in which a demand for speedy trial has been filed as provided in this code section results in a mistrial, the case shall be tried at the next succeeding regular term of court, which I believe would be September or October. I'm not asking the court to set a date now, but should the defendant for some reason not file a notice of appeal or something like that, we may follow up with the court and kind of look, and of course loop in counsel and say, maybe set a trial date for September or October.
You understand?
Absolutely no objection to a special setting. At this point, I'll let the court know we are intending to appeal. And if for some reason something changes, I will let the state and the court know immediately, but at this point, we are intending, since we get that written order. But I think that's it. All my pretty notes I had ready are not necessary because I'm assuming you will go forward with the pleadings for the arguments. I did, a little too late now, but I did want to introduce you, Your Honor, to Ms. Elizabeth Howard. She's working with my office and helping me note taking and all that. She's going to help me through the trial here or at a future date if for some reason we still have to go forward.
I thought you were going to show me missing, and if I was going to be in trouble with her, so I'm very glad that's Miss Howard right there.
Thank you. Thank you, and we'll get everything filed as soon as we get that over.
Okay, I might have seen this coming.
Thank you all. If that's all, court's adjourned.
Thanks, Judge. Good to see you.
Thank you.
Sorry for
Business of the week is-
Sorry for the